How you doing, ladies and gentlemen, handlers out there across the country? Ted Daus here from the Fort Lauderdale area, one of the four horsemen of the HITS conference. Uh, Recently retired of 30 years as a prosecutor down in South Florida, and most of you know me as my background is drug trafficking was what I did, and weaved in a little side kick of narcotic search and seizure for canine handlers. So, over 30 years of practice in law there, recently retired, and currently working for Fort Lauderdale Police Department on a part time basis. But I'm here to talk to you today with the help of Cameron Ford out here at CNCA to highlight one of the new hot topics that's floating around the country, which is ordering people out of cars related to canine sniffs. And like the general overreaction of our supervisors, our prosecutors, or maybe chiefs and captains, they may have heard about this. It is relatively new issue, like maybe raised its ugly head in the past 9 months. It's currently being litigated in Florida, and the issue has made it from your trial court level, with everybody's familiar with when you go to court for your motion to suppress or trials in general. It's made it through what's called the Second District Court of Appeals in Florida, which comes out really of the West Coast Tampa area, and it's now currently pending before the Florida Supreme Court. And it's kind of the nuance I want to bring to your attention of really testimony and a little bit weaving of the law. Because what really happened in a case called Kreller, it's Creller, and it'll probably get decided by the Florida Supreme Court this summer. And in Kreller, what happened was two police officers were involved in a traffic stop, and they were there on scene for about 5 minutes, and they'd basically gotten driver's license, registration, and proof of insurance. And for whatever particular reason, they wanted a narcotics canine, to come and sniff the exterior of the vehicle. So they made a call for their local canine handler to come out, and it took roughly 5 minutes or so for the canine officer to arrive from the initiation of the traffic stop. But while that 5 minutes was going on, those officers were standing back away from the occupants of the car. There was one driver and one passenger, and they allowed them to stay in the car, let's say, for that 5 minute period till the canine handler arrived. When the canine handler arrived, it was their practice, as we all know, that you could order occupants and drivers of the vehicle. The United States Supreme Court, if you go all the way back to 1988, is Pennsylvania versus Mims. Drivers could be ordered out at routine traffic stops. And then later on, I think roughly around the 95-ish, it was Maryland versus Wilson came out, where you can order all occupants, not just specifically related to the driver, but all occupants out at a traffic stop for, and I'll use my air quotes, officer safety. But and what had happened is the officer, canine handler, arrives. He gets out and he's going to run his dog, but now he's making the determination that he can't really deploy his dog safely with the occupants in the car. That was his preference, and thought it was because at some point in time, you're going to have a divided attention as a canine handler. You got to watch for change of behavior. You got to see the factors that the dog's in odor. The dog's going to take you as closest to source, and then you're going to have some kind of final indication, or what I like to call a final alert. Like a single purpose passive dog would probably be a sit. And so you really can't keep your eye on the occupants as you're circling the vehicle, doing a detail, maybe at some point in times having your side to the occupants, maybe at some point in times having your back possibly to the occupants of the vehicle. So it made logical sense that he would like to have the people ordered out of the vehicle, and you can do that at a traffic stop. Well, what the defense attorney argued, and I don't agree with it, but I understand the logic, is that if the first two officers were on scene for roughly 5 minutes, and they got driver's license, registration, and proof of insurance, and then for the remainder of that 5 minute period of time, they left the occupants in the vehicle, you can make a logical assumption that they didn't feel at that point in time, and again, here's my air quotes, that there was an officer safety concern that they needed to order them out of the vehicle. And in the two cases I told you about, those are the key phrases. And you got caught up in the testimony, unfortunately, and I don't really fault any of the officers on scene, um, because I never conceptualized that argument until the case came up. And I've been, lecturing for 20, 30 years now. Is that the term officer safety we used very cavalierly with canine deployments, because we were always used to order them out of the car. And the two officers on scene, non-canine handlers, actually testified, well, we ordered them out of the car to run the dog. And of course, Pennsylvania versus Mims and Maryland versus Wilson don't talk about ordering people out of the car to facilitate a dog search. They say ordering them out of the car for officer safety. The canine handler kind of did a duplicitous testimony. Well, I'm ordering them out of the car for officer safety because he's going to be deploying his dog, um, in order for me to run the canine effectively and safely. So he kind of gave a little bit to the officer safety, which is correct, but a little bit also geared towards to the ability to run the dog. And then the court in the Second District Court of Appeal ended up saying, well, the law doesn't allow you to order them out of a vehicle for the purpose of running the dog. And they suppressed the dog in the subsequent search and finding of the narcotics. And so that's being now litigated before the Florida Supreme Court. Probably, fair guess, maybe April, May, or June, we'll get an opinion from the Florida Supreme Court. But what is being tossed around, and I'm getting a lot of phone calls and emails, is they're saying, oh, my supervisors in certain areas of the country are aware, because it's popping up in a little bit here and there, that, oh, you can't order people out of a car at a traffic stop, or you can't order them out of a car if a dog's going to be used. And that's literally, it's not the Isaac Newton, the apple hit me in the head and the sky is falling. I'm of the belief that the Florida Supreme Court, which is in their judicial philosophy, is generally thought of as being 6-1 conservative, is going to make a determination, and I think it's legally sound, that officer safety is different for each perspective for each officer on scene. And the first two officers, well, first there was 2-on-2. So, if it was 1-on-2, the officer may have ordered them out of the vehicle for officer safety, because instead of being outnumbered is really what he would be, as opposed to being equally numbered with driver and passenger and two officers on scene. Nor did they take any other authoritative action to interact with the people other than driver's license, registration, proof of insurance. Then they step back and they are in a safer position, a safer tactical position, with those folks in the car with their back to them because they're behind either their vehicle or more towards the police vehicle. So they don't really have an officer safety perception concern or concern that they're thinking about, because they feel that if they needed to react, they could do so from the position that they're in. So ergo, for the first 5 minutes, I can see where there would be no officer safety concern as the facts unfolded. But now the third officer on scene is the canine handler, and I believe it's going to be well argued before this Florida Supreme Court that each individual officer has a different perspective and a different duty. And there is no time, I think they're going to say, hopefully, knock on wood, that they're going to say there is no time requirement from the United States Supreme Court in either Pennsylvania v. Mims or Maryland versus Wilson that says, like, that determination's got to be made in the first 60 seconds of the stop or the first 2 minutes of the stop. I don't think that they're going to put a time requirement on officer safety. And I don't see any reason why, if we delete the dog in this particular scenario, why they could have at this 5 or 6 minute mark somehow determined that there is an officer safety concern that has arisen, so therefore they could order them out at that point in time. I don't think they're going to be time determinative. I think they're going to say it's during the duration of a reasonable duration of a traffic stop. If something does rise to the level of a need to order them out for officer safety, you can. And it's not like you'll waive it if they're there for 2 minutes and you don't order them out. So therefore, anything that would happen at the 3 or the 4 or the 5 minute mark has been waived because you have to make that determination early. I don't think they're going to say that. And certainly if somebody arrives on scene that has a different task than the first two officers, ergo the canine officer, for all the reasons that we've already discussed, the deployment and divided attention and watching the dog and the placement of his posture around the vehicle, clearly is going to put him in a different scenario than the first two officers are there. So therefore, there really could be a sincere and would be a sincere officer safety concern for the second officer in his dog deployment if the folks remained in the vehicle. Because you always got to remember, you haven't touched them, you haven't seen their full force of their body, you don't really know if there's a bulge in the wrong place, you don't know whether there's a firearm in the center console or underneath the seat that they could get to, because it's an unknown area that hasn't been, well, you hasn't been discovered whether there is or isn't. Since it's unknown, it puts the canine officer 5-6 minutes later at a tactical disadvantage for the folks in the vehicle. So that's kind of it. So the apple's fallen. I mean, Newton's yelling, but the sky is not falling, so to speak. It's in litigation, and I get a lot of calls from handlers in Florida, and I don't want to get too much into the legal scenario, but it's actually not law. Because the case is written, the Second District Court of Appeal has written an opinion. You could pull it up, but in the procedural legal aspect of it, it's now pending before the Florida Supreme Court. And cases that are pending are not law. So it does exist. The philosophy is there. Bringing it to your attention because wherever you are in the United States, from the West Coast, East Coast, North Dakota to Texas, the issue could be argued by your criminal defense attorney, and it's going to get litigated in each of the states, and it may even get litigated in the federal government somewhere in one of the circuits. So the issue's there. I mean, it's just not going to be the end all be all in Florida. So it's coming to light that the philosophy and the legal argument can exist to be argued, but in Florida, it's not law until the Florida Supreme Court decides the issue sometime this spring or summer. So for any of the Florida handlers that are looking at, you should tell your supervisors, obviously your assistant state attorney prosecutors will know that if it's been cited as authority for a court to follow, it's not authority for the court to follow until it's been decided by for the Florida Supreme Court. It may be persuasive, it may help the judge decide the opinion, or some way it can be used as a philosophy to be argued, but it's not mandated for them to follow because it's not currently law. And you'll get this understand. Bottom line is it's in the pipeline. And if it's in the pipeline, it's not current law that mandates following. So just be aware. If you're ordering people out of cars, my suggestion is find the people at roll call that call you a lot, the good road patrol men and women that are out there that are have an ear, eye, or nose for dope in particular situations, and their spidey sense, women's intuition, gut reaction is that this may look like our narcotics deployment may be needed. Then order them out of the car for officer safety, and then when your canine arrives 3, 4, or 5 minutes later, that issue's been resolved because they're already out of the car. So it's not really to facilitate the dog search. It was they were ordered out of the car because you believe that there could be something rotten in Denmark based upon whatever facts and circumstances you have. So you've ordered them out of the car. And most traffic stops are going to be either even Steven, generally one officer with one occupant, or in this case, it could have been one officer. It wasn't, but it could have been one officer with two occupants. And you're outnumbered in an unknown container where weapons and things could be stored. So you may want to order them out of the car for officer safety. The canine arrives 3 or 4 minutes later. They're already out of the vehicle. So then the canine can be, you sniff the car as you find it. It's unoccupied, and the handler can do it safely. So that's kind of the nuts and bolts of the hottest ticket item that's currently going on out there. And if you have any questions, you can certainly catch me at ted@hitscanine.net is an email. So it's ted@hitsk and the number 9.net. And hopefully I'll see you in Phoenix this August in Phoenix, Scottsdale, Kirkland Resort, August 15th through the 18th for HITS, the nation's largest police canine conference. I thank Cameron for them letting me steal these 15 or 20 minutes for you, and look forward to hearing from you or seeing you at a future lecture.